Hello, my name is Dax White. I'm the managing partner of the White Law Group, and we are a national law firm that represents investors in claims against their brokerage firm. One of the most common types of securities fraud that we see involves churning or excessive trading. And today I want to talk to you a little bit about what that actually means. There's three basic elements that go into proving a churning claim. The first is control. And specifically what that means is that the broker has to have had complete control over the account, either through a letter of authorization that they would have signed at the outset, allowing them to trade without having to call you, or through what's called de facto control, which essentially means that through the course of trading, every time they made a recommendation, you followed it. And so you get to a point where there's enough of that going on where they essentially have de facto control over the account. The second element that you would need to prove to prevail in a churning claim is that the trading was actually excessive. And that used to be done through established turnover ratios that would apply. For example, if the turnover ratio in a specific year were 4, that was indicative of excessive trading, and if it was more than 6, that was considered churning. But the truth of the matter is that it really depends on the investor and what their goals and needs are. There are certainly investors out there who are younger, more active traders where maybe a turnover ratio of 6 is not considered excessive or churning. However, if you're a retired investor who's looking for income, this can be completely inappropriate. And ultimately what we really have to look at is FINRA Rule 2111 on quantitative suitability. And that's the rule that specifically applies in churning cases. And what that rule essentially says is that any type of trading strategy that can only benefit the financial advisor, and one where the financial advisor cannot demonstrate that it was a legitimate strategy intended to benefit the investor, is considered excessive and unsuitable and therefore probably churning. The third element that you would have to prove is scienter or intent. It has to be the financial advisor's intent to increase their commissions at the expense of their client. That's usually the one that's the easiest to prove, because ultimately if they had control and if they were trading excessively, they're going to know that they're getting those enormous commissions and they're going to have the intent to be doing it on purpose. If you have additional questions on what churning is, please check us out at churningattorney.com. Or if you're wanting to speak with an attorney and think that you've been the victim of churning, please call us at 888-637-5510.